Did you know that if you don't have a will, the state will determine who gets your assets when you pass? A lot of people are surprised by this. Some people think, well, the state gets the money. That's not true. The state doesn't generally get what your estate will be, but the state does have laws. They're called the laws of intestacy as to who receives your estate if you don't have a will or if you don't have an effective revocable living trust. So in Washington state, that statute is RCW 11.04.015. And frankly, I have done a whole hour on this topic on YouTube. You can find it. I've also done a chart which shows who inherits depending on what the situation is. It's not such a big deal if you are married, because if you are married and you have community property, then your spouse, yes, inherits from you. But let's say you have separate property and you don't have a will and you're married. Well, your spouse only gets a part of that separate property. The other property, the other percentages of the separate property go to your heirs at law. Who are your heirs at law? Your heirs at law, if you have parents alive, will be your parents. If you don't have parents alive, they'll be your children. If you don't have children, they'll be your siblings. And if any of your siblings have died, it'd be your nieces and nephews. So that's a real thumbnail sketch of who would inherit from you if you don't have a will. But even if you are married, please consult with an estate planning and elder law attorney. There is so much that can be done, number one, to avoid probate if probate's not going to be helpful, or if probate will be helpful, to protect assets for your surviving spouse so that they will never become impoverished. And just number three, to make sure things are easier for everyone who's in your life. Don't leave it to the state's laws of intestacy. You don't want that to be the situation to apply to your estate. And that's what will happen if you die without a will.